Well, now we're introduced to a very interesting situation. Admittedly, notaries don't encounter this very often, and for this reason, the procedure is not very well understood. We've stated and restated the fact that the document signer must personally appear before a notary in order for a signature to be notarized. We've said repeatedly that it's illegal for a notary to notarize a signature for someone who's not personally present at the time of notarization, and this is very true when a notary completes an acknowledgement or jurat. But if you think about it, there may be situations when a document signer is physically unable to appear before a notary. For example, someone might be leaving the state on business, yet they've been presented with a document that requires his or her signature to be notarized within a particular time frame, and it would be impossible for the signer to get to a notary public in order to complete it by that time frame. Certainly, we can think of other examples, but before we get into the situation, I want to make it clear that while we'll talk about a way to have a signature notarized without the person appearing before a notary, this method is only used because the document signer cannot physically appear before a notary, and not because the signer just doesn't want to take the time to appear personally. So let's introduce this procedure. If a person, we call this person the principal who's going to be signing the document, if this principal has signed a document, but they cannot personally appear before a notary, another person can appear before the notary on that principal's behalf to prove that the principal signed or executed the document, and they will prove that with an oath or affirmation to the notary. Now, that other person is called a subscribing witness. Now, I know that's a lot. Let me break it down a little bit more for you here, okay? Now, this procedure is called a proof of execution by a subscribing witness, or simply proof of execution. Now, the subscribing witness is that other person who's going to appear before the notary on behalf of the person who signed. Now, proof of execution proves the identity of the principal, which of course is the person who signed the document. Now, since a principal, the document signer, cannot swear to the truthfulness of the contents of a document by this method, or by the proof of execution method, it makes sense then that documents that would require a jurat would not be permitted to be done using this procedure. So we already have a limitation on this procedure, and that is we cannot complete a jurat for the document signer through a proof of execution, because the notary is required to obtain the oath or affirmation from the document signer for a jurat. Okay, that hopefully makes sense to you, and as we continue, I believe we'll even be able to clear it up even more. A proof of execution by a subscribing witness also cannot be used in conjunction with any power of attorney, quitclaim deed, grant deed, mortgage, deed of trust, security agreement, or listen to this now, any instrument affecting real property other than a trustee's deed or a deed of reconveyance. Now, what did you notice about that? Maybe you've noticed that these are the same documents that require a thumbprint in the notary journal. Obviously, the absence of the signer would necessarily mean that the notary could not obtain a thumbprint. So clearly, the procedure could not be used with these types of documents. So now we have two exceptions. The notary cannot use a proof of execution or a subscribing witness jurat, both the same thing, remember, with a document that requires the document signer, or the principal, to swear an oath or affirmation, which of course, as we said, is a jurat. And since these other documents that we mentioned, power of attorney, quitclaim deed, and so forth, since these documents require a right thumbprint, clearly the notary cannot get a right thumbprint if the person isn't there, so those documents are also excluded from this procedure. If you're feeling a little bit lost, it's for good reason. I would understand that. And we've just introduced a brand new notary procedure called a proof of execution, and you already know that it's used only in very extreme situations, and it requires someone called a subscribing witness to personally appear before the notary public. So now let's discuss just exactly how this process works. There's a lot of information here, but we're going to go through it methodically, and if you'll give me about 10 minutes or so, it really will be absolutely clear to you. A document signer who needs someone to take the document to a notary on his or her behalf, that document signer must personally know that person. And this is important because it's the oath concerning this personal knowledge that will eventually be used by the notary as identification. Now, we're going to talk more about that in a minute. Remember that the other person is referred to as a subscribing witness, and that's for good reason as well. The document signer must personally sign the document in front of that other person that we're calling a subscribing witness, or the document signer must personally tell the subscribing witness that he or she signed the document. In effect, the document signer is personally acknowledging signing the document in front of the subscribing witness, just as he or she would have done if they were in the presence in front of a notary. Now, once again, if you're feeling a little bit lost on this, don't worry. I understand. I know that it's a lot of information, but I'm going to clear it up for you. I really will. After the document signer personally acknowledges to the subscribing witness that he or she signed the document, that document signer must also ask the subscribing witness to sign the document. And notice that the document signer and the subscribing witness must be personally together. This can't happen over the phone. This is a situation where they are physically together, and the document signer has either told the subscribing witness that I've signed this document, or that the document signer will sign the document in front of the subscribing witness. Okay, now the subscribing witness, as we just said, is also going to sign the document at the request of the document executor. Once the document signer has asked the subscribing witness to sign the document, and the subscribing witness does sign the document as subscribing witness, and they'll just put underneath of their signature subscribing witness, then the document signer must request that the subscribing witness take the document to a notary public. After all, the document is still requiring a notary seal, so the only way this can happen is if the subscribing witness takes the signed document to the notary. Now, it turns out that notary law only allows one way for a notary to properly identify a subscribing witness. A subscribing witness is never identified by identification documents. Now you're probably thinking, what in the world are you talking about? Well, notary law requires that a subscribing witness be identified through another person who knows both the notary public and the subscribing witness. And what do we call that person? Of course, we learned from a previous section, that's called a credible witness. The point here is that the subscribing witness never uses paper identification to prove his or her identity to the notary public. Identification of the subscribing witness may only be done through a single credible witness. And also remember that when a notary uses a single credible witness for a document signer, the single credible witness is used because that credible witness personally knows both the notary and the signer. If there is nobody that knows both the notary and the subscribing witness, can't we use two credible witnesses as we've seen before? The answer to that is no. While two credible witnesses may be used if a notary doesn't know one of them in the case of identifying the document signer in normal situations, in this case, two credible witnesses may not be used. So the subscribing witness has watched the document signer sign the document, or the document signer personally told the subscribing witness he or she signed the document. And the subscribing witness has signed the document in front of and at the request of the document signer. The subscribing witness has now found someone he or she personally knows and who personally knows a notary. Together, both the subscribing witness and the credible witness are going to appear before the notary and request that the notary complete a proof of execution. Now, aren't you glad that this isn't done very often? Well, it's not. It sounds a lot more complicated than it really is, and you'll see as we continue on with this. By completing a proof of execution, the notary is going to certify the following: that the subscribing witness personally appeared before the notary public on the date indicated and in the county indicated. The identity of the subscribing witness was established by oath or affirmation of the credible witness, whom of course the notary public personally knows and who personally knows the subscribing witness. And the credible witness was properly identified in accordance with identification documents accepted under California law. All right. We have seen how credible witnesses are properly identified in a previous section, so you can go back through our identification videos if you don't remember that. But basically, Remember that the credible witness, even though the credible witness is personally known by the notary, the credible witness must still provide or show the notary a proper form of identification. Now, the notary must look at that form of identification, that could be a driver's license, passport, and the notary either records the identification document in the journal or has the credible witness sign the journal. It's not required to have both done, okay? Just a reminder, credible witness does not have to sign the journal. The notary public does not have to record the credible witness's information in the journal, but one of those has to be done. Now, you may also remember that it is the recommendation of the Secretary of State, as well as every notary who does this, to go ahead and get both anyway. Okay, so let's look at an example. In our diagram, the document signer is unable to take the document that he signed to a notary personally, so he asks someone who he personally knows to take it for him. This person is going to be called the subscribing witness because she will either witness the signing of the document or the signer will tell her that he personally signed the document. The subscribing witness must personally know the document signer. Then the document signer asks the subscribing witness to also sign the document, but will note next to his or her signature that she is signing the document as a subscribing witness. As you can see, the subscribing witness must personally be present in front of the document signer at the time the signer asks the subscribing witness to sign. The request cannot be made by phone, email, or fax, or in any other manner. All right, once the subscribing witness signs the document, the original document signer must ask her to take the document to a notary to have the signature notarized. Notice that the notary will be notarizing the subscribing witness's signature and not the signature of the original document signer. The subscribing witness must find a credible witness who personally knows her and also personally knows the notary public. Both the subscribing witness and the credible witness will appear before the notary, and the notary will first examine the document for completion and ask each one to swear an oath or affirmation. And so it's through this oath or affirmation that we're going to go through here that the subscribing witness is going to prove the identity of the principal, the document signer, because that subscribing witness is going to state under oath or affirmation that the person who signed the document as a party, the principal, is the person described in the document, that the subscribing witness personally knows this document signer, called the principal, the subscribing witness saw the principal sign the document or, in the presence of the principal, heard the principal acknowledge that the principal signed the document, and the subscribing witness was requested by the principal to sign the document as a witness and that the subscribing witness did so. Notice that this oath, unlike the oath the credible witness takes, does not prohibit the subscribing witness from having a beneficial or financial interest in the document. Isn't that interesting? All right, now for the identification process, okay? So the notary has already given the oath to the subscribing witness. We just talked about that. Now the notary is going to require the identification from the credible witness because remember, the subscribing witness may not use document identification or identification documents to verify his or her identity. The identification of the subscribing witness is going to be proven. It must be proven through the oath of that single credible witness. All right. The notary confirms the identity of the credible witness by using proper identification documentation, even though the notary personally knows the credible witness. This is nothing new. We've talked about this several times now. Then the notary is going to administer the oath or affirmation to the credible witness for the credible witness to establish the identity of the subscribing witness. You've seen this oath before. Let's just go through it again because it's a credible witness. Under oath or affirmation, the credible witness must swear or affirm that each of the following statements is true. That the individual appearing before the notary public claiming to have subscribed their name to the document as the subscribing witness is the person named as the subscribing witness in the document. The credible witness personally knows the subscribing witness, and the credible witness does not have a financial interest in the document and is not named within the document. All right, now it's the subscribing witness's turn to swear an oath or affirmation to the notary. Part of the purpose of this oath is meant to provide evidence of the identity of the original document signer. So, it's through the oath of the subscribing witness that the document signer is identified. Remember that the original document signer cannot appear before the notary, so that's why he's using a subscribing witness. So now the subscribing witness needs to swear or affirm to the notary the following: that the person who signed the document as a party, the principal, we call them the principal, is the person described in the document. The second part of the oath: the subscribing witness personally knows the principal. Third, the subscribing witness saw the principal sign the document, or in the presence of the principal heard the principal acknowledge that the principal signed the document, and the subscribing witness was requested by the principal to sign the document as a witness, and the subscribing witness did so. Okay, let's summarize this process up to this point. To perform a proof of execution, the notary must first examine the document for completeness, as always. Confirm the identity of the credible witness using proper identification documents, even though the credible witness personally knows the notary. The notary then, of course, administers an oath or affirmation to the credible witness, swearing to the identity of the subscribing witness. Then the notary administers the oath or affirmation to the subscribing witness, swearing to the identity of the principal. The notary then completes the journal entry for the transaction and attaches a completed proof of execution certificate to the document. Now, before we move on, I want you to picture this. Imagine the document originally required an acknowledgement, right? But the document signer could not appear before the notary. It was on a business trip or whatever the case may have been. So the document signer asked the subscribing witness to take the document to the notary on his behalf, or his or her behalf. The document signer signs the document in front of the subscribing witness, and the subscribing witness signs the document in front of the document signer as a subscribing witness in accordance with the information we talked about already. All of that should be pretty clear. Then the subscribing witness finds somebody who knows a notary personally, and both of those people go to the notary personally. Again, the second person that the subscribing witness is going to find will be a credible witness, because the subscribing witness's identification cannot be proven by identification documentation. So the credible witness now and the subscribing witness are present before the notary. The notary has identified properly the credible witness and has given the credible witness an oath or affirmation as to the identity of the subscribing witness. The subscribing witness then is given an oath as to the identification of the document signer. All right, so remember that the document originally had an acknowledgement on it, right? But the notary can't complete an acknowledgement because the document signer did not acknowledge signing that document to the notary. The document signer acknowledged signing the document to the subscribing witness. Now you understand why this is called a subscribing witness jurat, or a proof of execution. That's why, because the document signer is acknowledging to that subscribing witness that he or she signed the document, not the notary. So the notary cannot complete the acknowledgement. We need to have a completely different form, and that form is called a subscribing witness jurat. So just to restate this, a proof of execution is also called a subscribing witness jurat, since the oath or affirmation is given to the subscribing witness. Now, to complete the subscribing witness jurat, we see once again the venue is present, as always, and it's followed by the date of the notary act, which is the day that the subscribing witness and the credible witness appeared before the notary. In our example, the subscribing witness is named, conveniently enough, Subscribing Sally Trustworthy. The credible witness's name is Credible Christie's Friend. And remember that she personally knows both subscribing Sally Trustworthy and the notary public. As you can see, the document signer here was named, again, conveniently, document signer Daniel Absentee. It's not likely that you'll do many of these in your notary career, but you'll need to know about the proof of execution and how to do one properly. All right, now we need to look at journal entries. How to complete a journal entry for a proof of execution. course, be sure to complete the time and the date of the Notary Act, the type of notarial act performed. This type of Notary Act would be proof of execution by subscribing witness, or again, subscribing witness jurat, same thing. Type of document. Now again, the type of document is usually stated in the title of the document, but if the document doesn't have a title, just ask the subscribing witness to describe the purpose of the document, and then you record that description in your journal. Remember, proof of execution may not be used with any documents that require the thumbprint of the original document signer in the notary journal. Record the name, signature, and identification of a credible witness. Now, you may be saying, well, wait a minute, Dan, you just told me I didn't need to record all that. I'm suggesting that you record all of that, but this is what's absolutely required. The notary must obtain the signature of the credible witness or must record the type of identification document presented by the credible witness. Of course, the identification document always has the governmental agency that issued the identification document, the serial number or their identifying number that's on that identifying document, and the date of issuance or expiration of that same document. Now be sure to indicate the fee that was charged for the Notary Act and the signature of the subscribing witness. Now, just as a matter of note, you probably will want to print the subscribing witness's name in your journal as well, but only the signature is required. Okay, another best practice tip. We always suggest that you include the name of the principal in your journal as well, even though it's not required. So the more information in your journal, usually the better is the rule of thumb. Okay, let's go through an example of how this subscribing witness process might be used just one more time here. The principal, Paul, wants to have his signature on a document notarized. Now, Paul's in the hospital, not feeling too well, and he cannot appear before a notary public. So, Paul asked a longtime friend, Sue, to visit the hospital and act as a subscribing witness. When Sue comes to the hospital, Sue must watch Paul sign the document. Now, if Paul signed the document prior to Sue's arrival, Paul must acknowledge to Sue that he signed the document. Then Paul should ask Sue to sign the document as the subscribing witness, and Sue must do so. This should all be pretty clear by now. If it's not, you'll want to go back in and review this video, but it should be pretty clear by this time. All right. Next, Sue must take the document to a notary public. Sue chooses Nancy Notary as the notary public. However, Sue must bring a credible witness with her to see Nancy Notary, because a notary must use the oath of a credible witness to identify the subscribing witness. Sue chooses Carl, a longtime friend, as a credible witness because Carl has worked with Nancy Notary for several years. Therefore, Carl can act as Sue's credible witness. Alright, so Sue and Carl appear together before Nancy. Nancy personally knows Carl, but of course the credible witness process requires that Sue examine Carl's identification document, in this case California driver's license, in order to legally establish Carl's identity as a credible witness for the identity of Sue. Then Nancy puts Carl under oath. Under oath or affirmation, Carl swears or affirms that Carl personally knows Sue and that Sue is the person who signed the document as a subscribing witness, and Carl does not have a financial interest in the document signed by Paul and is not named in the document that was signed by Paul and subscribed by Sue. Then Nancy puts Sue under oath. Under oath, Sue will identify the document signer by swearing or affirming that she personally knows Paul, that Paul is the person described as a party in the document, that Sue watched Paul sign the document or heard Paul acknowledge that Paul signed the document, and that Paul requested Sue to sign the document as the subscribing witness, which Sue did so. Sue signs Nancy Notary Public's journal as a subscribing witness. Carl must sign the Notary Public's journal as a credible witness. Or Nancy the Notary Public must record in the journal that Carl presented the California driver's license, the license number, and the date that the license expires, and all of that information that we talked about earlier as well. Nancy now completes the Notary Public journal's entry. Nancy completes a proof of execution certificate, attaches the proof of execution certificate to the document. Sue then takes the notarized document back to Paul. My suggestion is that since that document is going to probably have an acknowledgement already pre-printed on that form, and the notary was not able to complete the acknowledgement, as we've already discussed, that the notary might want to just make an indication or a note to refer to the subscribing witness jurat that's attached. Okay, let's fill out the subscribing witness jurat here. We have the state of California, county of San Bernardino. On April the 9th, 2012, before me, the undersigned, a notary public for the state, personally appeared Sue. Of course, Sue would have a last name here. This is the name of the subscribing witness. Proved to me to be the person whose name is subscribed to the within instrument as a witness thereto, on the oath of Carl. And again, Carl would of course have a last name. Name of credible witness. A credible witness who is known to me and provided a satisfactory identifying document. Sue, being by me duly sworn, said that he or she, and you would circle in this case she, was present and saw or heard Paul, that's the name of the principal, again be sure you'll be including a last name, is the same person described in and whose name is subscribed to the within or attached instrument in his authorized capacity as a party thereto, execute or acknowledge executing the same, and that said affiant subscribed his or her name to the within or attached instrument as a witness at the request of Paul. Witness my hand and official seal, and of course you'll sign it and put your notary seal. And so that's how you complete a proof of execution by subscribing witness. Again, you may never complete one, but you'll need to know about this this type of notary act just in case. First of all, if it shows up on the exam, or in case you're requested to perform it. It's really not, as like I said, it's not that difficult. Much more difficult to talk about than it is to actually do, probably. Remember that the form is called a subscribing witness jurat, but if a document requires a thumbprint or the oath of the document signer, the subscribing witness cannot be used. Examples of documents which would fall into this category are any affidavit which require an oath or affirmation of the signer, and a power of attorney, quitclaim deed, grant deed, mortgage, deed of trust, security agreement, or any instrument affecting real property. Okay, you've seen that several times before now, so none of those documents would be brand new for you. Whew, that was a lot of information, but we're done with this section. Are you ready to move on to see what happens when someone cannot write their name? Yep, let's take a look.